I'm Kenneth Marcus, Chairman and CEO of the Louis D. Brandeis Center for Human Rights Under Law, former Assistant Secretary of Education for Civil Rights, and former Staff Director of the U.S. Commission on Civil Rights. It is good to be back. If you have been to the coat closet around the corner, you've seen my picture in the same suit but looking thinner. I mention history because I think you should be proud of it. It seems that few people here remember this. No, one or two folks are here from my tenure, and hi to Michelle sitting in the back. 20 years ago, this commission issued a report on campus anti-Semitism. It was a visionary report at the time for which you should be proud. It spoke with firmness, with courage, with unity, and with moral clarity. If you can do nothing more than to meet the same standard, I think that will be an achievement, and I hope that we won't collectively fall short of it. Let me share with you a few things about this history from those of us who remember it. So first, the Commission pointed out 20 years ago that Title VI covers Jewish Americans at a time then few people had remembered it. I had actually written the policy guidance only 2 years before that, in 2004, during which the George W. Bush administration established for the first time that Jews are covered under a civil rights statute that, as you heard this morning, bars discrimination based on race, color, or national origin, but does not mention religion. That was important at that time. It wasn't widely embraced as it is today, but this commission played an important part in raising public awareness of the issue, both through this report and its subsequent public education campaign. The commission, which heard a wide variety of views, but I think was clear on some fundamental truths, made some statements there that are worth remembering. One of them, from the 20-year-old report, is that anti-Semitic bigotry is no less morally deplorable when camouflaged as anti-Israelism or anti-Zionism. This was an important statement for its time. I think that it commands agreement, even among the various views that we heard earlier today, but it is important because anti-Semitism does have various disguises, and anti-Zionism, in that sense, brings forward to the present all of the same tropes, the same stereotypes, the same defamations that historically have befallen the Jewish people, viewing Israel as the collective Jew or Jew among nations. That is the form of anti-Semitism that we see most commonly on college campuses and that we need to address. This report was then followed by, in retrospect, a somewhat remarkable public education campaign on anti-Semitism, which in retrospect is notable in part because it embraced the international working definition of anti-Semitism, which would later be known as the IHRA working definition of anti-Semitism, meaning that this agency became the first U.S. federal agency to adopt what is now known as IHRA during the George W. Bush administration, even before the George W. Bush State Department would then start using it as well. It was more formally adopted, and I mention this because I think there was a little confusion earlier today. It was more formally adopted at the State Department under then Secretary Hillary Rodham Clinton as a really strong move by the then Obama administration, which used the working definition of anti-Semitism in concert with Democratic colleagues around the world in order to identify those forms of anti-Semitism that are sometimes hard to recognize because they can be coded as if they were political argument when in fact they're something different. This was an accomplishment, I believe, of the Obama administration. Later on, the Trump 1 administration, in which I was proud to serve, used that same definition in various enforcement activities at colleges and universities and then elevated it to the level of the executive order on combating anti-Semitism that was mentioned earlier today. It was also mentioned earlier today that that executive order adopting IHRA remained in effect throughout the last administration and to this day. Lest there be any misunderstanding, the Biden administration never rescinded Executive Order 13899, although it did rescind many other Trump administration executive orders, which means that the policy approach to using IHRA in civil rights enforcement has remained in place through Trump 1, throughout Biden, and into Trump 2, where it was then reinforced by a more recent executive order. The national strategy on combating anti-Semitism, which was an achievement of the Biden administration, might not be what I would have done, but it did indicate that IHRA is embraced by the United States government. It acknowledged that the Nexus document also exist and did so with praise. Nevertheless, there was no other definition of anti-Semitism that was adopted in any enforcement guidance by any other agency during Biden or Trump, which is to say that the IHRA working definition remains the one document which is a part of our guidance in the federal government, and not just in the federal government, but also in a supermajority of states throughout the country. About 2/3, not even counting Wisconsin, where the Assembly just voted on it earlier this week. So it is not just a definition, one definition among many. It's the only one that is currently and for several years part of our guidance in the federal government, in no small part with influence from this commission from 20 years ago. Why? Because anti-Semitism is sometimes hard to recognize in the way others aren't. We heard earlier today that other kinds of racism might not be defined in guidance. However, we know that sexual harassment is very commonly defined and debated and controversial in federal law, federal guidance, federal policies, and in the policies of universities and colleges around the country. Same with reasonable accommodations for disability. It is common to define those aspects of either identity or discrimination that need to be defined for practical purposes in order to identify forms of discrimination that would otherwise avoid notice. That's why we need to do it. During the Biden administration, we saw an explosion of anti-Semitic incidents, not just after October 7. I would say on October 6, 2023, as a civil rights organization, we were overwhelmed with the amount of complaints that we had received during the record-breaking prior years leading up to October 6th. It wasn't as if anti-Semitism just came about for the first time in October 7, and yet over the following weeks, we saw an explosion multiple times, even tenfold the number of incidents that we had seen before. Earlier today, I was very pleased that my friends in the prior administration remember that I had praised some of the things that they had done, and I was even more pleased that they have forgotten that I also criticized some of the things that they had done. The praise is that the prior administration, the Biden administration, continued the executive order on combating anti-Semitism and used Title VI in a forceful way, as I had recommended previously, including in the University of Vermont resolution agreement that you heard about just a few hours ago. The problem is that this approach, which was so important on October 6th, wasn't, in my view, up to the moment with October 7, when we had a crisis of historic proportions. I think that there has been general agreement that when one has a crisis, which is extraordinary and unprecedented, we need a response that's unprecedented and extraordinary. If there is a challenge from prior administrations, it is that there wasn't that sort of thing. If we need to understand what's happening with the Trump administration, we're seeing a whole of government approach using not just the Education Department, but also HHS, Justice, the Federal Acquisition Commission, and other agencies in an extraordinary way. And
Thank you, Mr. Marcus. I'm so sorry. We're going to have to wrap up. I look forward to the question and answer portion.